India's first major privacy law, the Digital Personal Data Protection Act, is heading toward a constitutional challenge at the Supreme Court. Multiple public interest litigations have been filed at the highest court, demanding the law be scrapped in its entirety. The core grievance published across major financial media is that the DPDPA enables a blanket denial of right to information requests involving personal data. Transparency activists and political figures argue this will shield public corruption by cutting off access to government records. The specific target of these legal challenges is Section 44.3 of the DPDPA, a provision that directly amends the legacy RTI framework. To see if these claims of a blanket ban are accurate, we have to examine the specific mechanical overlap between the DPDPA and the RTI Act. This intersection centers on a statutory contradiction that Section 44.3 attempts to resolve by deleting a specific overlapping clause in the original 2005 law. The conflict is actually about shifting the burden of adjudicating complex privacy rights away from vulnerable public clerks and placing it squarely on the judiciary. To understand the fix, we have to look at the 2005 baseline of the RTI Act and how it originally handled personal information. This diagram breaks down the original text of Section 81J. This section established the subjective conditions a public information officer, or PIO, had to evaluate before releasing data. First, the PIO had to determine if releasing the data would cause an unwarranted invasion of privacy. Second, the officer had to decide if a larger public interest justifies disclosure. Now look at Section 8.2 of the RTI Act, which operates right alongside it. Section 8.2 contains an overarching condition. It allows disclosure if the public interest outweighs the harm to protected interests. Both sections legally mandate the exact same balancing test. They both ask a government official to weigh public interest against individual privacy harm. Writing this balancing test into both 8.1J and 8.2 created a functional redundancy within the statute. In 2005, this redundancy was clumsy but functional. It remained that way until the legal definition of privacy shifted. The catalyst that broke this 2005 framework was the 2017 Supreme Court privacy judgment. The court elevated privacy from a standard administrative consideration to a fundamental right, increasing its legal weight against competing interests. This elevation shifted the legal burden onto the public information officer, who now manages RTI requests under a higher standard of constitutional scrutiny. A standard clerk was now forced to adjudicate vague legal thresholds, like what exactly constitutes an unwarranted invasion of a fundamental right, without judicial training. The 2023 DPDPA introduced a new systemic risk: strict, massive financial penalty structures for data breaches. This flowchart maps the escalating decision matrix a PIO faces today. If a journalist requests a list of personal beneficiary data, the PIO must weigh disclosure against these fundamental privacy rights at each node. If the officer makes a miscalculation and releases protected data, the government organization acting as the data fiduciary faces massive financial penalties under the DPDPA. Locally, the PIO personally faces severe disciplinary action and professional ruin for making the wrong subjective call. Expecting a government clerk to perform complex judicial balancing tests under the threat of financial ruin is an untenable legal framework. Section 44.3 of the DPDPA was introduced as the statutory patch to resolve this exact trap. Looking back at the text of Section 8.1J alongside 8.2, we can see exactly how the amendment operates. Section 44.3 simply deletes the subjective balancing clause from 8.1J. The section now collapses into a simple, objective rule for the PIO. There is no obligation to disclose personal information. The clerk is removed from the adjudication process. The public interest litigations focus entirely on this deletion, ignoring the other half of the equation. Section 8.2 remains fully intact and active within the RTI Act. If public interest outweighs the privacy harm, disclosure is legally permitted via the surviving 8.2 mechanism. Section 44.3 does not enact a blanket ban on information. It performs a surgical removal of a subjective redundancy to protect administrative clerks from professional liability. So, what is the new operational pathway for an investigative journalist filing an RTI request for personal data? The PIO's new standard operating procedure is straightforward. they apply the objective rule of the revised 8.1J and deny the request to avoid DPDPA liability. This flowchart maps the established legal recourse. The information request results in an objective denial by the PIO, which routes the journalists directly to petition a court or appellate authority. This pathway is legally optimal. The judiciary is formally equipped, trained, and mandated to interpret the balance of public interest versus harm under the surviving Section 8.2. Journalists argue this process hinders their ability to quickly expose public corruption. However, the government has officially clarified that personal information already made public by legal obligation, such as directories of public officials, remains entirely accessible and outside the scope of the restriction. When journalists need to access protected private data regarding specific government beneficiaries, they must do so through strict, purpose-based exemptions. The law denies blanket professional exemptions to journalists, lawyers, and doctors alike. Instead, it provides purpose exemptions, like research, which investigative journalists can utilize to access redacted data. The DPDPA ensures that while privacy is protected at the administrative level, the path to public disclosure remains open